Now, the Labour Court has rejected a joint application by the National Union of Metalworkers of South Africa, Numsa, along with the SA Cabin Crew Association, SACCA, aimed at halting job cuts at SAA. Analysts say that the layoffs will be key to reviving the fortunes of SAA, which is fighting for survival. But unions argue that the business rescue practitioners appointed to try and rescue the national carrier are attempting to push through the job cuts without following labour laws. The unions also want the court to force the BRPs to adhere to the terms of agreement reached last year that ended a crippling strike. Part of the wage agreement was that SAA would implement a training layoff scheme. All right, for a little more on this, we're now joined by employment and labour law specialist Osborne Molatudi. Thanks so much for joining us. Always a pleasure to have you in the programme.
Thank you, Peter.
All right, I guess in difficult economic times such as this, we're going to start to see more and more of these kinds of disputes where Section 189s are likely going to be issued. SAA, we saw the unions going to the Labour Court to say they must stop trying to fire people. I just want us to take us, step by step through the laws, because they are worried that the laws are being flouted. What's your take on what's happened so far?
Thank you, Peter, and for the opportunity, and good afternoon to our viewers. Perhaps one needs to start in the meaning of dismissal for operational requirements, which is contained in Section 189. But it basically means that an employer is entitled to dismiss employees for operational requirements based on its economic, technological or structural changes, or even its similar needs. So under those circumstances, an employer is entitled to issue a notice inviting employees to participate in a process which in the end is meant to either avoid the retrenchment or minimize the effects, or if no alternatives are found, the employer is then permitted to go ahead and effect the retrenchments. What is critical is that there is a duty to consult on the part of the employer, to consult the affected employees, and if they belong to a trade unions, to consult the trade unions. If there's a workplace forum, to also engage the workplace forum. What is further important is that consult means exactly that, to engage, and not necessarily to negotiate and agree on every aspect pertaining to the process.
All right, so if we take it step by step, if a business practitioner says, it's likely we might have to cut jobs, that's not necessarily an announcement that it will happen. It's a consideration. From that point on, once you consider it, you've got to give the notice, isn't it? That you are even considering it, even if you haven't started the process.
The distinction there is that the employer is not making an announcement that it is contemplating dismissing the employees for operational requirements. It simply makes an announcement on ways in which it can conserve the cash flow, on ways in which it can survive pending maybe in due course, some possible process in due course. So that is very critical. It is not announcing that it's intending to retrench employees. It's simply making an announcement.
It could be.
In terms of the means in which it could make use of to avoid ailing further and further, basically to conserve cash. And I guess that was a central issue at the Labour Court. However, I cannot comment on that case. Because I wasn't involved,
right.
And all I can do and assist your viewers just to outline the process, that once that announcement is made, it must be carefully analyzed as to whether it constitutes a notice in terms of which they are invited to make representation as to why they should not be dismissed for operational requirements. And there's a whole lot of other things that they need to consult on.
Is there not a requirement that even if you are not going to go through with it, that the moment you're considering it, that you must inform the employees?
And I think that's what most employers, prudent employers, will do that. However, the duty to consult only arises when you contemplate dismissing them.
Okay.
So the ways in which and the means in which we want to follow to try and preserve the business, etc., without contemplating dismissal, then the duty to consult does not arise. It only arises if you say, employees, this is what I intend to do, and if these measures fail, in the end, the likely effect is that I'm going to retrench. Then that duty to consult arises.
Okay, and then the consultation process, it may not be a negotiation. You might literally be saying, look, this is what the story is. If the labor can say, look, we'll offer this, we'll work half days or whatever it is, then you move forward. But if even that doesn't help, the employer then says, look, we've consulted, unfortunately we still have to go ahead with this.
I think the advantage for trade unions and or affected employees is that once they've made representations to the employer is obliged to consider those representations. One of which is that the employees may offer to work less hours. Some may even offer to get a pay cut. Others may agree to a voluntary severance package, etc. So that whole basket of issues, as per the representation from the trade unions or the affected employees, will have to be considered by the employer, and the employer will have to give reasons why it is accepting or rejecting any of those aspects as per the representation.
So quite a lot has to happen before the actual retrenchments. There's another contentious part of this where a manager was seen on video telling staff, listen, you probably don't need to come for work after a certain date. Now the question now becomes, a manager somewhere at a depot saying this to employees, does that now constitute an announcement by the company? Or is he acting ultra vires, out of his power?
On the frolic of his own, because he's panicking. It will depend on the circumstances of that announcement. But most employers will have protocols in terms of which announcements are made, and precisely to avoid people going on the frolic of their own or out of panic making unnecessary panic announcement to employees. And like I said, that will depend on the facts of each case. But I'm told, I haven't read the judgment, that this wasn't accepted by the Labour Court, where a manager at the depot or at the station or Cape Town station made that announcement. That I believe it wasn't accepted. But more importantly is that a prudent employer will issue a formal notice. I mean, we all know that by now. There's a Section 1893 notice. It's pretty standard. It sets out what are you intending to do, what have you considered to avoid the retrenchment, dates which the retrenchments are likely to take effect if there's no consensus. Inviting the other side to come and consult on a whole number of issues, the critical ones being, are there ways in which we can avoid the retrenchment, etc. And that is the formal notice that people should regard as
all right. We've run out of time, but one last very important question. So I'm wondering whether the corporation is still bound by an agreement that they may have reached with staff to end a strike before the business rescue practitioners came in to say, we've got to give layoff training and all these kinds of things. The business rescue practitioner then steps in. He can't afford that layoff training. Are they still bound by that, or is this another layer of creditors that they need to manage with?
You're trying your luck. You want me to dwell into the SAA merits. But if the BRP is not bound or considered himself not bound by that collective agreement, he's entitled to follow measures in terms of which he's employed precisely for that business rescue. And therefore, he may have to engage the affected trade unions and or the employees to explain why, firstly, he does not see himself bound by that collective agreement, and secondly, why he believes whatever that was agreed, it's not affordable to the organization in the long term. But overall, it's all about consultation, engaging each other,
and that seems to be
trying to reach consensus to avoid the possible retrenchment. And the most important thing is that trade unions cannot just sit back and expect the employer to roll out everything. They need to engage. They need to participate. They mustn't boycott the process. And our courts also encourage both parties on either side to have an open mind about the issues that have to be discussed during a retrenchment process. Okay. And this has been done for many years, and it's not going to change until such time that the law changes on retrenchments.
All right. Osborne Molatudi, always a pleasure to talk to you, and your insights always invaluable. Thank you so much indeed for your time.
I thank you.
All right.